in S versus I'm sorry, at paragraph 29, the Leonard Arthur Murdoch Watney in 2014 SAR 855 at 870 states that, and we quote, it is submitted that a more flexible approach, so the author is also making the same argument as the writer Ditoe does, that a more flexible approach in the admissibility of evidence is required, and the discretion of courts in this regard should not be unnecessarily hampered. Greater relation of the rules about hearsay evidence entail and are alive to the inherent dangers involved in its admission. They should therefore be entrusted to decide the admissibility of all forms of hearsay, including we mention here, including extracurricular admissions by co-accused, and if admitted, what weight to attach to the evidence. And at page 867, the writer states that the Ndlovu case did not hold that all hearsay evidence should be admitted. A decision not to admit hearsay evidence can therefore not be construed as deliberately deviating from the approach followed in the Ndlovu case. The writer then refers to the case of Libazi, 2010, volume 2, SSCR 233 SCA, wherein the court, in not allowing the hearsay admission, the writer argues that the court, in not allowing the hearsay admission, cannot necessarily be construed as criticism of the approach in the Ndlovu case, and went on to argue that it was never the purpose of Section 31C to allow all hearsay evidence, but to grant a court the discretion to allow it.